You're listening to the Valley Current.
Okay, excellent. We'll do that at some time. So tell me, well, I run a podcast, I'll send you some links, called the Valley Current, which has been talking about the evolution of Silicon Valley around the world. And I've done that as I've taught different classes throughout the world as I capture information. So you're now sort of back from England and resident in San Francisco. Mm-hmm. As I remember last time we had a discussion, you were still, I think, in Europe, but maybe you were back, possibly you were back, and I don't remember. But you're in San Francisco and working in San Francisco where?
So I'm running the San Francisco office of a consumer insight and brand strategy agency that's headquartered in Brooklyn.
Okay.
And the last 12 years I've been here in San Francisco.
Wow, so a long time.
Yes.
You're back.
Yes.
You're fully back.
Oh, yes. And I spent 7 years at Goodby Silverstein and Partners, an advertising agency, one of the best in America, working on mostly Fortune 100 brand related communications, positioning, storytelling, consumer insight.
Okay.
And then I left and I went to work with Wells Fargo after their settlement. And I think it's an organization in a very vulnerable posture and very open to learning from mistakes, but just open to learning, period. And I came in to teach folks in their in-house agency and across parts of their 1,800 person marketing department.
Wow.
What empathy is, why it matters, and how you do it. And it was a really powerful experience. I rolled that out as a kind of half-day workshop from coast to coast, and I taught with some of my colleagues there. And it was powerful. It was transformative. And then from there, I left to run head of marketing for a fintech, a mission-driven fintech, they had one product, which was a credit building loan for low-income folks in America and the states where they're allowed to operate. And I really got to learn a lot about how to help underserved communities, primarily Hispanic communities in the U.S., start to build generational wealth by developing some financial health, understanding basic things like what a credit score is and what it can do for you and how it could harm you if you don't take care of it. And I was really passionate about that experience and would have stayed were it not for an old friend knocking on my door saying, Heather, please, would you open my San Francisco office? There's so much work with clients on the West Coast. I don't know why people need to fly out from Brooklyn. And I would love your help in building a bigger business and exploring more complex problems, since the West Coast tends to focus on the future. What's the future of, for example, media was a question I got from Intel. And so through consumer questioning, really moving into rich spaces and the role of how a question can open up a world, can open up very differentiated types of responses.
Yes.
And the whole initiative to reach out to you and to talk with you really as a question expert from a legal perspective and as a person who's experienced a lot of life in a variety of roles is to look at what happens to the common question, the obvious question, when you take the time to kind of push and pull things apart, when you are invested actually or become invested in a better question, maybe a strategic question or creative question, because you can see the impact. You can see, an exponential shift in information, quality of information that comes in when you ask a more considered, a sharper, more strategic question. We do that for Fortune 100 clients in service of, brand engagement or product innovation, or messaging. And you really come at it from an entirely different perspective. I think we're interested in, I watched, by the way, the link you sent me to
good.
Irving Younger.
Yes, great.
The man was breathtaking. What a force of nature.
He died at the age of 56.
Yeah, I read.
It's shocking because he had a long career ahead of him. Had he been able to live, say, to the average age of 76 or 79 or 82 or whatever it is right now.
Yeah. No, he was extraordinary, and I feel really privileged actually to have spent the time watching the way he talked about questioning and cross-examination and his principles, his convictions, his energy.
Right.
And I think that's something also that I'd love to explore with you is how we change, how people change when you bring what's alive within you to what you question, how you connect with people. And I think that was really Irving Younger's tremendous gift from an outsider's perspective, is how much dynamism he brought to, short questions, plain words, right? Was one of those top principles. I have prepared for us a discussion guide, and I don't know if you would prefer to have, more organic conversation, but I have a few things that I prepared in the spirit of the legal process of, preparation. But I'm open if you want to open with questions for me. I'm welcome, or I welcome that as well.
Well, let me say first that there are really at least a dozen different types of questions that lawyers use. Mm-hmm. Lawyers who are really good at questions understand that taxonomy. Mm-hmm. Most lawyers don't. So that's a way of saying most lawyers are not really practicing what might be called the art of questioning. So most law these days is transactional. Even litigation tends to be transactional. Mm-hmm. So even a lot of people that are quote unquote litigators, they really are transactional people just negotiating settlements. Mm-hmm. You could think of the art of advocacy as dating back to the time of Lincoln, or really the time of even before Lincoln, the 1700s, or even maybe the 1600s, when people really did engage in questioning. And there's at least a dozen different styles. So I should just make a preliminary statement that what Irving Younger represents is what might be called the style of destructive cross-examination. That is the very pointed questions designed to make the beginning of a closing argument, not the entire closing argument, but the hint at where the closing argument is going. And a lot of lawyers, unfortunately, never really get the experience of doing that because they never really get to trial. They say they're doing litigation, but they really never try cases. They don't understand juries. They don't understand judges. So that's a whole different topic, but there's at least 11 other types of questions other than destructive cross-examination. And Irving Younger, I thought you'd get a kick out of, because I think of destructive cross-examination as probably an important fraction of what you have to understand about the art of questioning, because most good questioning in the legal field is more Columbo-like. He was a detective. We could probably find the link to him and then put on some video from him where it was just like he played dumb. I don't understand. Explain that to me. Can you please help me? I think 2 and 2 equals 4, but you're saying it equals 5. He was very, very pedestrian, and it was more conversational questioning. We're going to have more of a conversational questioning back and forth. You're going to ask a bunch of questions. I'm going to feed in, hopefully, the other 11 examples of types of questions. But the 2 endpoints are destructive cross-examination at the pinnacle of what a lawyer does at trial against the person that's lying under oath, a perjurer, versus very open-ended, conversational. You don't even have to ask a question. You can hint at a subject, and I'm volunteering information. So those are the endpoints. And there's a whole spectrum of questions and art of questioning in between those endpoints. Think of it as a funnel where the top of the funnel is the conversation, the open-ended, tell me more about yourself. Would you tell me more about yourself? What have you been doing for the last 12 years? That sort of question versus, how is it that you can imagine this to be a fact when A, B, C, D, and E, and pretty much the person is cornered into some sort of trap. So I think that there's some 10 different other styles of questions or types of questions we can talk about. But why don't you start with your questions, and I'll try to classify it, and we'll have an unscripted game because this is all in real time. And you can decide to use this however you wish in the course of your book chapter that you're writing, right?
Yes.
You're writing a book chapter here, right?
Yes. The idea is I've been talking with Paul, who's our CEO and founder of Now What, and over the 15 years he's been running his company, they've really invested the time, worked with experts to explore, what questioning does for people. And over those years, he feels they've developed this expertise. They are question masters themselves, as I imagine you to be. And the idea is for us to look at very humbly, just to begin with, what do questions do for lawyers?
Right. So lawyers are like information vacuums. They are trying to get all the puzzle pieces that are obvious to get snapped into place. And then the unobvious puzzle pieces often that are missing from the board are being located or somehow identified or somehow abstracted. So you could think of a trial as a process of filling in a puzzle board where a lot of the puzzle pieces are often not disputed. Dates are set, particularly now with email, a lot of puzzle pieces get created almost instantly right out of the email system. So this whole nature of the way we've moved more conversations to electronic media means the puzzle pieces are all there, they're recorded, they exist, there are dates, there are times, there are stamps. You can get all those on the board. But oftentimes the board will be missing questions of intent, of motivation, of subjective state of mind, of was this an accident? Was it inadvertent? Was it a mistake? Is it a coincidence? Was it a desired effect? So lawyers are looking for what might be called the unobvious puzzle pieces, and the questions that open the door to what's missing from a case really arise out of the lawyer's creativity in putting together, look, I think this is the scenario, but it could be this scenario, but it could be that scenario. Well, let's look at what might be called the inferences from the evidence that we have versus the inferences from the evidence that we don't have. And oftentimes the best lawyers have a great sense for sniffing out the inferences that are correct from the puzzle pieces that are on the board, even though there might be other puzzle pieces that would completely change the board. Right now, you have a nice background that sort of has a pattern of, birds and bird cages and freedom of flight. And I guess it's a tree or a vine. I'm guessing it's a tree. And, if we were missing a lot of what's there, we would have to guess at, are there birds? Are they colored white? And are there cages? Are the cages open? Are they closed? And we would be guessing about that if the puzzle piece wasn't complete. But the puzzle is complete. The wallpaper is perfect. It looks great. And it tells a story. And there's a story there. Now, what question could be framed around that story might be what you would do with what's in your background. Most cases these days tend to be very sophisticated puzzles and not something that can simply be answered from obvious information. And that's where asking the right questions hopefully get you to the right answers or to some interim state of having additional puzzle pieces. So this whole process we call discovery in litigation. In non-litigation, it's called investigation. So in non-litigation, like a corporate investigation, you see this when there's a sexual harassment claim or discrimination claim. A corporation will do an investigation. The investigation will be like an internal set of questions, not necessarily a formal process. Sometimes under oath, sometimes with recording, sometimes with even things like polygraphs and the like. But by and large, it's kind of like, let's get all the puzzle pieces on the table and we'll figure out what's really here and what's not here. So along the way, there's a lot of open-ended questions, a type of question where you just want to know the who, the what, the how, the why, the when, the basic 5, buddies of any reporter, of anyone, just any human, when did you start doing that? How did you start doing that? Da, 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 da. Those are just basic instincts. And I agree with you that lots of people cannot frame the relevant question that really describes the case. So I like to start a lot of cases and even at oral argument with what should happen when a blank does blank in a circumstance like this, because then you load a lot of the story into the question. And if you can do that in a way that's compelling, judges love you, because judges will say, male, female, or otherwise, hey, look, I understand what you're saying. You framed the exact issue correctly. Or they might say, no, I think you have not framed the issue correctly for this, that, or the other reason. And you'll get a lot of pushback.
Can we break that down or slow that down a little bit for folks like me outside of the world you work in, that what should happen when? So for example, in advertising, when as you're talking, I'm thinking about how brand strategists work on a single-minded idea. If you need to get a product out into the world, what's the one truth about this thing? And Irving Younger makes that point of the power of one question.
Right.
And so this idea, you have an operating single-minded idea or a single-minded framework of what should happen when. And then could you talk a little bit more about how you came up with that framework, and if there are any others that help you, how you get to that framework?
Right. I think it's very much case specific, and the leading opening question in a brief or an argument or anything else will kind of depend on what type of case you have and what specific facts you have. But in general, most people listen for about the first 90 seconds and almost instantly decide whether, yes, I should listen more. We live in a world with a lot of noise, so we have to be respectful of our audience. And there's at least 5 pillars that audiences will look at. And so framing a question around those 5 pillars, so the 5 pillars go something like, and they all start with the letter C, so it's easy to remember. It's almost like 5 C's. So number 1 is you have to have a certain competence in the area that you're acting as an advocate in. So I wouldn't do a personal injury case because I'm not really competent for that kind of case. I've actually done historically many years ago some personal injury cases, but that's a long, old history. I'm not currently someone competent in personal injury cases or bankruptcy cases or tax cases. My competence is in business litigation, internet, intellectual property, and so on, all the stuff that's on our website at computerlaw.com. But competence has to be sort of linked to what I would call credibility. So the first C is competence. Competence leads to credibility because people really believe that you know what you're talking about. If you do know what you're talking about, which means you have to study the file, you have to read the documents, you have to interview witnesses, you have to know what people are going to say and what they're not going to say, and what the experts are going to say and what they're not going to say. So framing that opening question kind of requires you to have your arms around the case. So in what you do for brand strategy, you'd have to have your arms around kind of the consumer sentiment. How do they feel about shampoo at this particular time in their life? I don't know if you're doing shampoo right now, but shampoo is what comes to mind. And people are like, I'm not taking that many showers anymore. I mean, that might be one sentiment. So I really want a shampoo that works fast and maybe works without water. I mean, I'm just making this up, but conceptually, you get my drift. So you have to have competence, you have to have credibility, and you have to be very clear in combining those two things in a way that expresses the theme for the case in the opening question or in the opening series of questions. And you don't get a lot of time because people immediately will judge that you're either incompetent, not credible, or not clear. And it's easy to fall on any of those three legs of even the first three of the 5 different C's that are out there that I think of, really, really requirements for lawyers. A lot of lawyers fail on any one of those first 3, and we have 2 more that we have to accomplish. But along the way, if you can't frame the case simply in a way that is in one non-convoluted sentence, it has to be a really simple words, very direct, very easy to understand, very believable. If you can't do that, you are going to lose credibility, or people are going to think you're incompetent, or people are going to think that you're not being very clear, and you're wasting their time. You're not being respectful because they're there sitting there often feeling like a caged bird. So in some ways, your wallpaper is like right on. And so, it's hard to express this in a way that says it's a formula, but I think of it as get immersed enough in the subject matter. So if you have an account, I think you have to spend a lot of time with the product or the service, and you have to feel like you understand what the consumer is actually thinking about the product or service. You have to actually feel like you are the consumer, or you have the consumer sentiment. So I could tell you that people will also these days in the legal business test whether or not the question lands or the theme lands, and they use all sorts of novel tools that are available even online. So I've had some clients that have allowed us to use things like consumer surveys where we pick the demographic of the jury we think we have, say in San Francisco or San Jose, or if I'm trying a case in New York or Washington, D.C., or anywhere else that we have cases and practices in Seattle and Portland, Oregon. We'll basically say, what does this jury think about this subject matter? And you'd be amazed at how much information you get from even a very basic survey. And surveys are not necessarily the best. And I know there are people that think that they can be botched. And I know there are even people that have tools that search the internet for sentiment based on keywords. Of course, the internet is very noisy. So I don't know if that's really out there. You probably know this area better than I do. But I know people think you can take the noise out and get more signal out of it than noise. So
I'm interested in a couple of things that you talked about. So we got 3 out of the 5 C's. I was wondering, I want to circle back, make sure we get all 5, but also writing the questions for your questionnaire. So when you test a question, I'm interested, first of all, are they open-end or closed-end questions? And how do you create questions to test a question?
Yeah, there's a lot of drafting and redrafting, at least mentally. I would say, actually in writing too, there's a lot of sort of sharpening and getting rid of noisy words, or getting rid of words that are too argumentative. Lawyers can become easily too shrill and too argumentative. And so there has to be a certain element of, and this is really the 4th C, creativity, because you have to bring, and this is really what lawyers bring to the table, in fact, but people don't realize it. They bring some creativity at arcing the missing data. arcing the storyline that is not obvious. Like if you have a case that's obvious and all the puzzle pieces are there, you don't really need a creative lawyer. You need a lawyer that's a good mechanic to kind of get the paperwork through. But the cases that are most challenging are where the lawyer has to be super creative, and that creativity is arcing the missing pieces with other small breadcrumbs of evidence that the lawyer's questioning and tying of answers to questions together. So the fourth C tends to be the lawyer, actually the hard work of lawyering when it's actually being done, which is not a huge percentage of the time, unfortunately. You know, these flow moments of feeling like you've captured the missing link and you figured out how to get there. That's the creative flash of genius. And when that happens, that's what justifies the huge hourly rates, because people really don't need you to just be a better typing service. They don't need you to be a better, filing agent or filing manager. They can get that in millions of different ways online, but they need the creativity, and they really need different forms of creativity. We can get into that in another time because it's a really deep subject. But what lawyers do when they do their best practice, and Irving Younger gave examples of it, is piecing together things in a creative way to actually create the way for people to see what they see, and then convince them that they are in fact seeing it correctly. So the last of the five is the lawyer has to resonate confidence. So this notion of competence is almost multiplied or becomes exponential by the level of confidence. So the lawyer that can ask those questions or respond on his or her feet spontaneously, without notes, without cue cards, without notepads, without index cards, literally has a heads up, because people are like, wow, that person knows the case inside out. That must be correct. It must be right. They're not scripted. They're not, this is not some sort of Bill Maher show where he's reading some lines. I mean, he's pretty good at doing stand-up, but by and large, he's scripted. He's a nice guy, smart, funny, but it's all a script. And when he doesn't land because people don't think it's spontaneous enough, he gets pretty upset. If you watch him carefully, and by the way, watching stand-up comedy is really worthwhile doing if you're going to engage in the art of questioning, because some of the best stand-up comics do it really, really well, and some do it poorly, and you can actually learn from both of them. But by and large...
How do you tie the comedy to the questioning?
Tune in next on The Valley Current.